Hi, I'm Sarah Franke, and I'd like to welcome you to Jackson Kelly's webinar, Litigation in the Marcellus and Utica Shale Deposits, a four-part series on case law in West Virginia, Ohio, and Pennsylvania. Today's webinar will cover oil and gas case law updates in West Virginia and will be presented by Roddy Steger, an attorney based in our Charleston, West Virginia office. Roddy?
Thank you, Sarah. Good morning or good afternoon, depending on where you're joining us from. As Sarah indicated, I will be providing a presentation today focusing on West Virginia, and this will be part one of a four-part series. So with that in mind, my goal is to get this finished up within the 30 minutes that we've allotted so that I don't take up too much of your lunch hour. So with that being said, I'm going to go ahead and proceed on. We're going to be covering West Virginia, and I show here briefly the topics that I have put the cases into, the first of which is the surface rights and interests. And the first case I'd like to start talking about today would be Faith, the United Methodist Church versus Morgan. That case arose from Calvin Foreman, who held the fee interest to a 225-acre tract in 1869, ultimately passed his interest along to his 7 children, each receiving a 1/7 interest. And then 5 of those children eventually sold their interest to their brother Walter. Florence, who initially held out, ended up selling her interest to her brother Walter, but it was only in the surface only. Ultimately, Marvin Morgan acquired his interest from Walter, and he asserted that he had sole ownership of all of the oil and gas. The churches disagreed because they had received Florence's interest, and they asserted they still had a 1/7 interest in the oil and gas. So the question that was presented to the court was what this surface only meant. The circuit court ultimately ruled in favor of Mr. Morgan, noting the Ramage decision basically held that the term surface was always ambiguous and could not be universally applied. The court interpreted the deed against Florence and found that Marvin had sole ownership of the oil and gas. On appeal, the Supreme Court of Appeals overruled the Ramage decision, and it looked to other jurisdictions and some statutes within West Virginia to ultimately define the term surface. As I showed on the slide, surface estate is defined in other code provisions in West Virginia, and ultimately the Supreme Court came up with this definition for surface: the exposed area of land, improvements on the land, and any part of the underground actually used by a surface owner as an adjunct to surface use. The court noted that Ramage was outmoded and unjust, and its hope was that the Faith opinion would prevent and eradicate uncertainties in land titles. So hopefully Faith, if the term surface only ever arises, you can certainly rely upon Faith to provide the framework and guidance of what that actually means moving forward in West Virginia. Martin v. Hamlet is a case I don't want to spend too much time on because it is from 2012, and I'm sure that most of you are probably aware of what it generally stands for. But Mr. Hamlet actually opposed EQT's filing and receipt of a well work permit by the DEP. And the question for the court was whether or not a surface owner could challenge the issuance of a well work permit. And ultimately, the Supreme Court determined no. Mr. Hamlet relied primarily on constitutional arguments under due process and equal protection that a surface owner should be able to appeal a governmental decision affecting his or her land. And the court did away with that argument, but most importantly, the court looked to West Virginia precedents on the surface use and the Buffalo mining opinion, the Squires versus Lafferty opinion. You know, surface owners' rights are generally subject to a mineral owner's rights, and a mineral owner can make reasonably necessary use of the surface to extract its minerals. And that's long-standing law that's been around since the early 1900s. The court also noted that it was the contractual obligation under the lease and not the well work permit that actually deprived the surface owner of his unfettered use. So the constitutional arguments did not hold water. The court also noted that the surface owners are not without remedy. There's the Surface Damage Compensation Act, which allows them to recover for surface damages, and also common law action if they want to assert that the lessee exceeded their rights under the lease. So they're not without recourse. The Martin opinion is a good segue into the Whiteman versus Chesapeake opinion, which recently came out in the Fourth Circuit in September. There, Chesapeake conducted operations on 10 of the Whiteman's 101 acres. And on that 10-acre tract, Chesapeake was going to operate 3 wells and also utilize an open pit system to dispose of its drill cuttings. And the Whitemans disputed whether that was reasonably necessary within the terms of the lease. Interestingly, the Whitemans pointed out that there were closed-loop systems being used in other locations throughout the country, but the open pit systems were being used in this region in the Marcellus. So, that was sort of an interesting point. The court ultimately, as I'll allude to in a moment, didn't find that argument to be particularly persuasive, and it found that an open pit system was, in fact, an acceptable use of the property. But the Fourth Circuit traced the reasonable necessity standard all the way back to its inception in the 1800s, and then focused primarily on the Buffalo mining opinion, which I mentioned earlier. It noted a subtle distinction, however, and the subtle distinction is between implied rights as opposed to express rights. When you're dealing with implied rights, the court found there's a 2-part test. 1, has to be reasonably necessary, and 2, it cannot impose a substantial burden of the surface owner. So the example the court gave, if you're drilling a hole on a limited portion of the property, that's probably okay as an implied right. But if you're going to conduct activities that would essentially use the entire surface, then that would probably require express provisions. So with that framework in mind, the court noted that it's always going to be a fact-intensive process, and what's necessary is a fluid concept. And applying that framework, ultimately the court found that what Chesapeake was going to do on those 10 acres was reasonably necessary and did not pose a substantial burden to the 101-acre surface tract. So I think Whiteman will be used often in the future if you run into any of these surface use cases. I think it's a fairly favorable opinion and ultimately probably a good result. Thornsberry versus Cabot also recently came out in September in the Supreme Court of West Virginia. The Thornsberrys owned the surface and Cabot held a lease, but entered into a 2006 agreement whereby it was going to construct a road 200 feet across the tract in exchange for a payment of $500, and it also agreed to stack the salvageable timber and give it to the Thornsberrys. Ultimately, Cabot constructed a 1,300-foot access road, drilled a well, and erected an above-ground pipeline. Thornsberry sued for breach under the 2006 agreement, and they asserted the road exceeded the appropriate length, it was in the wrong location, and that Cabot did not provide them with the timber. Cabot responded that its operations were appropriate under the lease, and that the 2006 agreement was really only entered into out of an abundance of caution and had no effect on what they were actually allowed to do on the property. Cabot also relied upon some exculpatory language included within a 1941 deed that basically prevented the surface owner from, or precluded the mineral owner from being held liable for any damage to the surface. The Circuit Court ultimately agreed with Cabot and granted summary judgment. Supreme Court of Appeals reversed, found that there were issues of fact as to whether or not Cabot breached the 2006 agreement because it superseded the exculpatory language found in the 1941 deed. Now, the interesting thing about Cabot, there's a few interesting things. One, I think the court's holding implicitly found that the 2006 agreement may have also superseded the lease on at least those 3 points. Additionally, it wasn't clear whether or not this was, the Thornsberrys asserted that the lease had expired, and the court found that they were not a party or in privy to the lease but gave no holding as to whether or not they could challenge the lease's validity. So it would have been nice if the court had made a decision on that issue, but I think that lessees can continue to argue under Justice versus Pennzoil that surface owners who are not parties to leases cannot challenge their validity. And for purposes of time, I'm going to keep moving. On in the contamination tort cases, Hagee is one I'm not going to spend a whole lot of time on, but the Hagees essentially sued Equitable for water contamination of their water wells. The interesting thing about Hagee is Equitable had the surface owners enter into waiver releases prior to conducting drilling activities, and the Fourth Circuit took a look at the language of those releases and noted that the claims essentially waived any and all claims arising from or relating in any way whatsoever to drilling operations. And based on that language, the court granted Equitable summary judgment, finding the plain language covered the claims, that EQT had paid due consideration for the releases, and that the Hagees had an adequate opportunity to consult legal counsel, and the law presumes that they knew the contents of what they were signing. So this notion that, well, how are these surface owners supposed to know any better? Fourth Circuit did not find that particularly persuasive and said they had an opportunity to consult with counsel if they so chose. Keller versus Temple, another tort case. I don't want to dwell on it too long. Automobile accident. An employee of a pipeline company actually struck the plaintiff on his way to work, and the plaintiff attempted to file suit against Apex and claim respondent superior for the automobile accident. Plaintiffs pointed out that the employee was driving to work and that Apex may have provided for payment for his gas. They also cited some unique circumstances attendant in the oil and gas industry that should support their argument that Apex should be held liable, but they didn't really provide much support for that argument. The issue was whether or not the employee was acting within the scope at the time of the accident. And in West Virginia, we have adopted the going and coming rule, which means an employer cannot be held responsible for an employee's actions while he's coming or going to work, coming from or going to work, and only where there's additional evidence presented that would link the employer to the incident could they be held liable. Here, the employee was driving to work. There was no evidence to suggest the employer was related at all to this accident, and so summary judgment was granted to Apex. The next case in our next segment here on contractual obligations and provisions, EQT versus Fountain Place, and this is actually a photograph of Logan County's Fountain Place shopping mall. Two pipelines at issue. Fountain Place held the surface rights, EQT the lease. There had been about 30 feet of dirt placed on top of one of EQT's pipelines over the years, and EQT ultimately determined that it wanted to move the pipeline at a cost of $158,000, which it did. There was another pipeline over which Fountain Place wanted to construct a cell phone tower, and they started doing some digging in the vicinity of the pipeline, and EQT didn't think much of that either, so it decided to bury that pipeline at a cost of $45,000, and the issue was who should have to pay. The court applied the two-part test in Quintain versus Columbia. First thing you do is you look to the language contained in the agreements, in this case the lease and the deed, neither of which provided for any sort of payment. Step two, you look for who benefited from the change in the status quo. In this case, the installation of the pipelines was not the status quo because that had occurred before Fountain Place obtained its interest in the property, and thus it was the relocation and burying which actually changed the status quo, and both of which benefited Fountain Place. Therefore, Fountain Place was responsible for making those payments. The next case, Exploration Energy Partners versus Mountaineer Gas. I'm not going to spend any time on this case. I provided it in the materials in case you run into a forum selection clause issue. It provides you with the four-part test that you need to show to enforce those provisions, and so you can more than welcome to take a look at the PowerPoint for that. Same thing with Ennis versus Chesapeake. I'm not going to spend any time on that as well. The interesting thing about this case is the commencement date was left blank, and ultimately the court found, although it's an essential term, It was a no harm, no foul. The lessee had done and commenced operations appropriately long before whatever commencement date the plaintiffs could assert should apply, and therefore the court had no problem enforcing the lease. Flat rate leases, another one I'm going to move quickly through. Wellman versus Bobcat Oil, it was a flat rate lease, and ultimately the lessee had continued to make appropriate flat rate payments. Therefore, relying on the Bruin decision, production is irrelevant, and as long as the payments are made, the lease is going to continue to remain valid. So that's ultimately the court upheld the lease in Wellman. Royalties. Royalties cases are generally difficult, I think, for at least me to read through. I have to read them multiple times, but this one I thought was interesting. It's also very recent. It came out here within the last few weeks, and it provided some perspective on the Tawney decision, which most of you are probably aware of, a 2006 opinion from the Supreme Court. 14 leases, all with similar but different language, and the opinion focused primarily on the plaintiff's claims for breach of contract. The plaintiffs argued under the Tawney decision that EQT could not withhold post-production costs from, or they could not deduct post-production costs from the royalties they were paying. And I'm going to focus on the post-2005 actions of EQT. EQT, after producing the gas, would then sell it to another EQT entity at the wellhead, and that other EQT entity would pay the index price less the gathering charges and retainage. And then that was what EQT based its royalty payments on, the price that was paid by the other EQT entity. In considering this case, the court gave a good review of all the royalty cases in West Virginia. That's why I think it's a good opinion to read. If you ever have a royalty case come up, you can kind of get it all at the same place. But you have the evolution leading up to the Wellman and the Tawney opinions, and essentially the Wellman opinion provided that unless the lease provides otherwise, lessees may not deduct post-production costs. And then the Tawney case elaborated on how a lease can provide otherwise. And ultimately, there was too much ambiguity in the Tawney case, and the court imposed or interpreted it against the lessee. But Tawney stood for at least 3 points on this specificity issue. One, the lease must expressly provide the lessor shall bear some part of the costs between the wellhead and the point of sale, and I highlighted point of sale, and I'm going to talk about that in a moment. Second, the lease must identify specific deductions the lessee intends to take from the royalty, and also the lease must indicate the method of calculating the amount to be deducted. And so the court pointed out this point of sale in the first Tawney factor, but then the Southern District determined that the Supreme Court of West Virginia actually meant to say market. It didn't mean point of sale. And they said that because the issue in Tawney was the cost of delivering gas to the transmission line where it was bought and sold by third parties, i.e. market, not point of sale. I think the court probably did this because it would add some predictability. Point of sale could be upstream or downstream from the market. The market's the first place there's a willing buyer, and that title can pass to that buyer. So in this case, the court found that the true requirement, unless otherwise provided by the lease, would be EQT was responsible for all post-production expenses until gas reaches market. The court found that the EQT to EQT transfer was not the market and was not a bona fide sale. And I'm going to skip over the plaintiff's other volumetric deduction, but ultimately, of the 14 leases, the court found that only 2 met the Tawney specificity requirements, and there's the language that the court found was sufficiently specific. The other leases contained similar, but they just did not spell it out as precisely as these 2 leases did. So, I think the point in sort of reiterating the Tawney decision is that if a lease is going to allow a lessee to deduct post-production costs, then it needs to be very specific in how it does so. I provided a couple of sites here for removal cases. If you get into these declaratory judgment actions or injunction actions and you're worried about whether or not you can remove them, versus a case where plaintiffs seeking punitive damages and everything under the sun, I think these cases will give you a good framework to work from. The issue is the value of the object of the litigation and not what damages are specifically sought. There's pretty good law. The Northern District's been pretty good about applying that law. So I would recommend if you run into that issue, these are two good cases to take a look at. And then we have a couple of pending cases that I want to talk about, and I'm going to be brief. But the TransEnergy versus EQT, probably the most interesting pending case we have. That case arises from an 1892 Blackshear lease between John Blackshear and South Penn Oil Company. And in 1901 and 1902, South Penn entered into indentures with Carnegie and Hope to sever South Penn's natural gas rights from their oil rights. The issue in this case arises from the fact that neither of those were ever recorded. And EQT ultimately succeeded Hope and Carnegie and went on to operate two Marcellus wells on that 3,800 tract in Wetzel and Doddridge County, West Virginia. On the other side of things, the South Penn chain ultimately led to Pennzoil, who then in 1996 assigned its interest in Blackshear to Cobham, and there were two exhibits to that agreement, and then Cobham assigned its interest to Prima in 2004, and both of those assignments were recorded. And as you can see, Prima actually paid Cobham $250,000 plus 250,000 shares of TransEnergy stock for that assignment. The most interesting fact about these two exhibits is that Exhibit A listed all the oil and gas leases, and then Exhibit B listed all the wells. And on the columns listed on Exhibit B, it also listed the lease numbers associated with the wells, the farm name, the well numbers, the acreage of the leasehold, and the rights contained or conveyed with the wells. Well, only oil was listed on Exhibit B next to the Blackshear wells. In 2011, TransEnergy was granted a well work permit, and it subsequently conducted additional title examination on the property, which for the first time revealed EQT's competing interest. So the issue was who owns the natural gas rights to the Blackshear property. Ultimately, the district court sided with TransEnergy, and I think ultimately the court sided with them because they had the record chain of title. They had the best chain of title, if you will. On appeal before the Fourth Circuit, there's going to be this is a very factually intensive case, and both parties have done a fairly good job at outlining why they both should win. The briefs were long and interesting, but essentially EQT is making two arguments. One on the chain of title issue, it refers to a 1927 letter from South Penn, which actually referred to Hope owning the gas. Hope is who EQT obtained their title from. It also points to the Exhibit B oil reference in the 1996 assignment, and then they actually went out and had the drafter of the 1996 assignment execute an affidavit which indicated that Pennzoil only had the oil rights. They also assert that there was a lack of due diligence on Prima in its 2004 assignment, that Prima should have been aware through legend and lore of the oil and gas division back in the early 1900s, and that it should have been on notice given EPC's well operations on the property, and also a lack of consideration, and those go to the bona fide purchaser issue. On the flip side, TransEnergy, it continues to refer to its unbroken chain of title. There's no mention of anything in the record room regarding EQT's alleged interest. It discounts Exhibit B, and it discounts the need for this affidavit as parole evidence. Basically rely upon its chain of title. It also contends it was a bona fide purchaser. There's no that its due diligence was adequate. That there's no way it should have known from 2 wells located on a 3,800-acre tract with a bunch of hills and forest that another company was out there operating and drilling for gas, and that its consideration was appropriate. So we could probably spend 30 minutes talking just about this case. It's a very interesting case. It's scheduled for oral argument on December 12th, and you can, if you go to the Fourth Circuit's website, you can make arrangements to watch the oral argument, and I would expect it to be excellent. The last case I wanted to address, Kane versus XTO, and I think you'll hear this mentioned in the fourth part of our series, because I think this will be an issue that continues to come up over the next 6 to 12, 18, 24 months. But in that case, a surface owner of 105 acres sought to prevent the lessee from drilling horizontal wells from its surface. And the surface owner did so by referring to the 1907 severance deed, which basically only allowed the mineral owner to extract, to drill from the surface to extract gas from underneath that same tract. And so because this was going to be a horizontal well, it was not actually going to produce any gas from beneath this particular tract, but would be producing from some of the other adjacent tracts. Judge Keeley thought this was a pretty interesting issue, interesting enough to certify the question to the Supreme Court, and ultimately the parties ended up fighting about whether or not it was ripe at that point. She ultimately determined it was a bit premature at that time. She withdrew her order to certify the question, and the case ended up being dismissed in November of this year after the parties reached a resolution. But I do think this is an issue that will come up again. I think it will be something that surface owners may rely upon in leases that have somewhat similar language but do not have pooling provisions. I think they will try to make this argument as broadly as possible, and at some point there may be a decision. I think this may be something that will need to go before the Supreme Court of West Virginia, but has not yet. It's a very gray issue, and I would imagine it would be something we would see in the future. So with that, I think I've gotten through all my slides within the allotted 30 minutes. I appreciate your participation. Thank you very much.